So when I say that we've been lucky enough to bring on literally the top expert today, I'm not joking around. And I could go on and on and on. I'm going to introduce him now. I would say the oracle of the TCPA, Tom Cunningham. Tom, thank you so much for doing this. We really appreciate it. The political industry appreciates it. Our audience today appreciates it. I'm going to just hand this over to you and let you take this away.
Well, thank you, Josh, and really thank you for that kind introduction. I'm going to have to add Oracle to my web bio now. And I really
It's fitting.
appreciate you having me here today and the opportunity to speak with you and your audience about the risks of bulk texting, even after a very favorable Supreme Court ruling in the Facebook versus Do-Good opinion, and ways that organizations might mitigate the remaining risks of being sued under the TCPA for bulk texting. You know, the subtitle of my presentation today is "The Class Action Plaintiff's Bar is Resourceful and Relentless." And we definitely see that in the wake of the Facebook opinion. As we all know, the TCPA contains statutory damage penalties that are very significant and create significant exposure for organizations that are using bulk texting. There's every incentive for the plaintiff's bar to continue filing lawsuits under the TCPA, notwithstanding the Facebook opinion. And frankly, as you'll see as I work my way through my presentation today, they are doing just that. There are continuing risks for organizations that are using bulk texting technology. So let's start with the Facebook opinion itself. The Facebook opinion, as I mentioned, was a very favorable opinion. Basically, the Supreme Court reined in what many of us felt was a runaway trend in the Ninth Circuit, but also outside the Ninth Circuit, in what technology constituted an automatic telephone dialing system under the TCPA. And as we all know, in order for the TCPA to apply, the technology used to send a text message must be defined as an ATDS, or an automatic telephone dialing system. Basically, the Supreme Court returned us to more of a text-based definition of what constitutes an ATDS. But there's still a little bit of ambiguity, and many people have heard of what is now sort of an infamous argument known as the footnote 7 argument. Without getting too deep in the weeds of footnote 7 of a Supreme Court opinion, the court basically said in dicta that a system might need to both generate numbers and randomly or sequentially dial them for technology to be considered an ATDS. And many defendants in lawsuits that have been filed under the TCPA since then have said, well, our system doesn't generate a number, and therefore it's not an ATDS. And that's a good argument, and it's an argument that I've made and that we will continue to make. But unfortunately, the rulings in the district courts are not consistent. So far, we've seen a real mix of rulings. We've seen some favorable rulings, but we've also seen a number of unfavorable rulings. And when I say unfavorable, I don't necessarily mean that courts were finding liability against defendants, but simply denying motions to dismiss, which obligates you to then litigate a case to conclusion, or denying a motion for summary judgment, which forces you to go to a trial, or more realistically, settle the case for a significant amount of money. As I said, the plaintiff's class action bar is both resourceful and relentless. They're not going away. And I've got a slide here where I indicate the statistics last year show TCPA class action filings were up 18.7% in 2023 over 2022. That's after the Facebook opinion. So these cases are persisting, even though we have a favorable ruling from the Supreme Court. We've also seen a significant uptick in claims being filed under state laws. There's many state laws that are modeled on the TCPA. And, you know, the state courts operate a little bit differently than the federal courts. So we're seeing more cases being filed there. The U.S. Chamber of Commerce just reported last month on the continuing threat of the TCPA in the wake of the Facebook ruling, and I commend that report to those of you who are interested in what's happening since Facebook was decided. That report indicated that plaintiffs' firms have presented creative arguments to get around the clear ruling in Do-Good, and conjure up theories of expanded liability since the decision was first published. That's consistent with what I'm seeing in the industry. Like I said, plaintiffs' lawyers are going to keep coming at this. But there is an alternative to bulk texting. Bulk texting leaves a defendant exposed to potential significant liability under the TCPA, because you're going to have to successfully argue in a case where you've used bulk texting technology that the equipment used does not qualify as an ATDS. And you have to hope that the district court goes your way on that, which it might, but it might not. The alternative is peer-to-peer texting. Now, peer-to-peer texting has already been reviewed by the FCC, and the FCC has indicated in a declaratory ruling that a real peer-to-peer texting platform is not an ATDS and therefore does not implicate the TCPA. Real peer-to-peer texting platforms require a human being to send each message. They require text messages to be sent one at a time. They lack the capacity to transmit more than one message without a human being manually dialing each number. And they have no capacity to store or produce numbers, nor randomly or sequentially dial those numbers. Because they have all those features, and because you have an FCC declaratory ruling that expressly states, we make clear that if a calling platform is not capable of originating a call or sending a text without a person actively and affirmatively manually dialing each one, that platform is not an auto dialer, and calls or texts made using it are not subject to the TCPA's restrictions on calls and texts to wireless phones. You've got a very powerful argument to dismiss such a case or to obtain summary judgment. And in fact, that is what we are seeing in the courts. There's 3 cases that I'm aware of in which text messages sent using a peer-to-peer text messaging platform was challenged. The first one is a case called Pascal versus Concentra out of the Northern District of California. In that case, the court granted summary judgment for the defendant, finding that a peer-to-peer texting platform did not constitute an ATDS. That case is significant because it was appealed to the Ninth Circuit, and that decision was affirmed or upheld. In Berger versus Republican National Committee, a case out of the Eastern District of Texas, again, the court granted summary judgment for a defendant that used a peer-to-peer texting platform on the basis that that platform did not constitute an ATDS. And finally, in Bowman versus Unterman for Congress, a Northern District of Georgia court, the defendant filed a motion to dismiss. It was never ruled upon. The case was settled for an undisclosed confidential amount immediately after that motion was filed. One might speculate that the plaintiff in that case saw the argument and preferred to settle on some reasonable basis rather than take the risk of an unfavorable ruling on that motion. So the case law so far involving peer-to-peer texting platforms is pretty much 100% for the defendants, whereas the case law on the footnote 7 argument under Facebook is kind of a mixed bag. There's some wins, but there's some losses too. TCPA risks are going to continue despite that Facebook decision. But if you're using a peer-to-peer text platform, you've got a much stronger argument for dismissal based on the FCC's declaratory ruling and this new case law development.
Now, one thing I'm wondering is, say, for example, there's somebody that's out there, obviously not with Peerly, but they're sending out like a robo-text, and they get sued, or there's a problem, or the FCC sues them. They're going to go to court, and I'm sure that they're going to bring up the Facebook footnote 7. And as we, I think, both agree, it's a good case. There's some merit there, just hasn't probably been thoroughly tested the way we would want it to be. More than likely, I'm not an attorney, but that's probably something that would eventually have to go to summary judgment. And if it does have to go to summary judgment, what would the cost be for that defendant to make it all the way to summary judgment using something like Facebook 7 in court. Do you? I'm not going to hold you to it. It's not a quote for services. I'm just curious because I want people to understand that there's always risks in everything you do, and some of them can be pretty expensive.
Sure. Fees in these cases, Josh, as you probably know, can be quite high. It can cost hundreds of thousands of dollars, if not millions of dollars, just to win these cases. And as an aside, that's why the plaintiffs' lawyers keep filing. Even when they're not convinced that they're going to win, they'll file the case because if they think they can cost a defendant $1 million in legal fees to defend a lawsuit, they know the defendant will pay something less than $1 million to settle that case. So, if they think they've got a 50-50 shot at defeating a motion to dismiss or motion for summary judgment, they're going to file that case. There's really no disincentive for them to come. And the defendant is going to incur that, from anywhere from a couple $100,000 up into the millions of dollars, depending on how large the case is and what the circumstances are in legal fees, just to win the case, just to defend and win.
And if it goes all the way to judgment, and we know that there's no guarantee on anything, and I know there's no guarantee in anything. This is it's relatively untested. If this was brought all the way to the end, it could cost millions of dollars to defend it, but.
Absolutely.
If that particular judge on that particular day decides that that's the arguments merit in favor of the plaintiff and you lose, now what could be the consequences for something like that?
Well,
financially,
it's ruinous. I mean, the statutory damages under the TCPA are $500 per call or text, up to $1,500 per call or text, if the court determines the violation to have been willful. So, you look at how many text messages you send or how many text messages are typically involved in your typical lawsuit. It doesn't take very long before they exceed the ability of most defendants to actually pay those judgments.
Yeah, it could be complete financial ruin.
Complete.
And that's where, on our end, we've been saying the same thing, that, if we have the declaratory ruling, it's very clearly written. Let's rely on this and let's let other people develop Facebook versus Do Good maybe on their own dime. In the meantime, I don't know. I see the merit and I actually do like it, but like you said, I like the FCC ruling a lot more. So if just to kind of summarize some of this down, would you recommend one of these political campaigns to kind of ignore this ruling in favor of relying solely on this Facebook Do Good case? It seems like you're pretty clear with your advice on this.
No, I think as I indicated in the presentation, you have on the one hand a pretty clear ruling from the FCC that peer-to-peer texting platforms do not constitute an ATDS, whereas the Facebook decision contains some ambiguity, and there's some room for disagreement in the district courts on what does and doesn't constitute an ATDS. So you take a little bit of a risk if you're going the Facebook route, but if you take the FCC's declaratory ruling, at least the cases we've seen so far less risk.
Great. I really appreciate it, Tom. That really summarized this. I really wanted our audience to hear from you directly. When a lot of this was talked about a year ago, it was done by, I would say, just like a medium-sized firm in the industry where they were outright advising people, you do not need to follow the FCC. Instead, rely on this case solely. And as far as I've seen, they did not bring in any experts. They didn't have any attorneys. So, it's nice that now it's a year later. We probably should have done it a lot sooner, honestly.
Yeah, we should have.
But I'm glad we've finally been able to get an expert to the industry to hear it directly from them. And, I appreciate that it was you and you were able to fit us into your schedule. So thank you very much, Tom. I really, really appreciate it. Really appreciate your time today.
Well, you're more than welcome, Josh. I'm glad I had an opportunity to be here today.